all too often you travel down to London, whether for court hearings, conferences or APL events. So we welcome this opportunity to travel up to you instead. To reciprocate and show our thanks for your instructions. And in the light of the train disruptions today with over an hour's delays, to gain fresh insight into the logistical challenges your trips to London involve, and for which you display such calm and equanimity. The firms and organisations represented in this room are among our most valued clients, and we are so glad that you've come to join us today. We have 5 sessions for you, and we'll introduce each session and speakers as we get to them. The first 3 will take us to a coffee break at 3:30 p.m. and the aim is for the last 2 sessions to finish at about 5 p.m. After that, we hope that as many of you as possible may be able to join us for drinks and catching up socially in the lobby outside. And with that, I allow Philip Stear to take the floor to introduce our first talk on Section 57. Thank you.
Thank you, Nick. So, here is the title slide for the first talk that Nick and I are going to do, which is entitled A Novel Jurisdiction, Section 57 of the Trustee Act 1925. Now, it's possible to choose what you think is a crisp and engaging title for a talk, and only notice the obvious mistake a bit later. Novel would be an odd way to describe it in the sense that it's been there since 1925. So what do we mean by novel? Well, I think the way to demonstrate that might be to take a vote. How many of you are familiar with Section 57 of the Trustee Act? Regularly think about whether it might help you. Well, okay, I've got a couple of members of House of Temple Chambers who've been intimately involved in things connected with Section 57, raising their hands. Shouldn't have included you. So I don't think I've had any hands. It doesn't matter. It's not a test in that sense. Because what I was going to say was, if anybody said, yes, I know about it, I was going to say, I bet you've done quite a lot of private client work as well as pensions, haven't you? Because what we really mean by novel is not novel so much as neglected or overlooked, particularly in the pensions context. If you were a private client lawyer, you probably would have thought about it a little bit more. That's because this section of the Trustee Act is something that sits, I suspect, alongside the variation of Trust Act 1958 in the minds of private client lawyers as something which might allow you to change the terms of your trust if it's necessary to consider that in the light of circumstances that have developed. And of course in pension schemes we don't typically need to think about it like that, because most of the time we think of ourselves as having amendment powers in our schemes, which enable us to make the changes which keeps the scheme up to date with modern circumstances. Those sorts of powers don't generally exist for tax reasons in private trusts. And consequently, it is the statutory jurisdictions of variation of trusts and this provision that private client lawyers might typically find themselves looking for. The question we want to raise is whether it's got useful applications in the pensions context when you've got a restriction on your amendment power, which means that on this occasion it can't be used for what would be useful to do. In other words, even though generally we're not going to need to resort to these sorts of powers, might it be useful on those occasions? And there is a case that we're going to come to in which a number of people at Outer Temple were involved, where judgment was given in March, Pennon Group Pension Scheme, in which Section 57 was invoked to give a release, if you like, from a bind that the trustees found themselves in as a consequence of the provision of the trustee. We'll come to that in a moment, because it's probably useful to just look at the elements of the jurisdiction first. So that's the text of Section 57, and you can see that somebody has highlighted 1 or 2 phrases which might be integral, key to the existence of the jurisdiction, and basically they are that you have a problem arising in the management or administration of trust assets. That means management or administration of the trust itself, and where there is, well, if we just go back actually, if I know how to do that, I do. If we look at the list, you see there's, in that old-fashioned drafting style, there's a whole list of different things, and then the catch-all at the end is probably what gives you the sense of what the overall governing purpose of the categories are. So the first list ends up with or other dispositions, so dispositions, and then purchase, investment, acquisition, expenditure, or other transaction. So we've got dispositions and transactions as the governing concepts there, and in the management of administration of the scheme. So those are the first two things. Are you in the management of administration? Have you got a disposition or a transaction? And then crucially, would it be expedient, in the opinion of the court, for that transaction or disposition to be undertaken, but the trustees lack the power to do it, whether by statute or under the terms of the trustee, because in those circumstances the court may grant the power with which to make the transaction or other disposition. So, with that, over to Nick.
Well, the key distinction in terms of the breadth of the jurisdiction under Section 67 is between rewriting beneficial interests and conferring powers that are expedient just in the management or administration of the trust property. And the normal phrase that gets invoked is from Sutton in England in the Court of Appeal in 2011, saying that there's no jurisdiction under Section 57 to confer a power to depart from the beneficial interests under the, that should be trusts, not trustees, by rewriting, remoulding or rearranging them. But it's not quite as straightforward as that, as we see from Sutton itself, which approved a prior Cayman decision called the Z Trusts, about the partitioning of funds. So while you're told that you can't rewrite, remould or rearrange beneficial interests, you are permitted, it's established, to divide the trust assets into two separate partitioned funds. For example, you might give one limb of a family trust the property interests, and the other limb might take the share interests for reasons to do with tax or other conveniences. And the fact that having partitioned the fund, one side may get more and one side may get less, is considered an incidental effect rather than remoulding or rewriting the trusts. And that might be relevant, we'll come on to look at that later, to how you might be able to use Section 57 usefully in the pensions context. So moving from that broad divide between remoulding or rewriting the trusts to look at quite how it has been used in other cases. On the one hand, there's the great list of forms of dispositions that you can make, and then the other, the coda to the phrase saying, or any other transaction, which seems an incredibly wide jurisdiction as to the powers that can be conferred in the administration or management of the trust assets. And it's notable that it's not limiting to conferring a power just to effect a specific single transaction that you've got in front of you there and then. It can include enlargement or variation of powers generally. It's not limited to conferring a power just to affect the transaction itself, but could include ancillary powers to facilitate operation of the power. So imagine the power is to make a particular change in a pension scheme. Arguably, it would also, the Section 57 jurisdiction would also extend to an ancillary power to amend the deed and rules to reflect the other thing that you're doing, so that it was reflected on the face of the instruments thereafter. The key overriding restriction, of course, is the fact that it must enable the trustees to implement or undertake transactions or be a necessary ancillary provision relating to that additional power, and that seems to be one of the litmus tests for not rewriting or remoulding the trusts. And the sheer breadth of what can constitute a transaction is illustrated in the case law. And there are cases where quorum requirements for exercising an amendment power have been effectively disapplied to facilitate amendments being made, and you can see that being relevant in a scheme with a very cumbersome trustee board where you can't get unanimity as to a particular change. You've had cases substituting entirely new investment clauses. So the earliest pensions case that I think we're aware of Section 57 being used in was Mason and Farbrother, as long ago as 1983, where there was no amendment power and they realised that their investment powers were completely too old-fashioned, but they couldn't amend in any way. You've had cases where powers to adopt an entirely new consolidated governing instrument has been given. So that's a Jersey case called Breville Bath Fund, where it was such an old and such an informal trust that there was simply no sensible governing provisions at all. You've had powers to appoint trustees that aren't otherwise allowed, and you've had other changes to do with administrative provisions, and critically, just to illustrate it, disapplying a rule against self-dealing, because it's not just an absence of a power under your deed and rules themselves, it's or under any other law, whether the wider law or statute. And it's also clear from the case law that the fact that there is an express prohibition in your deed and rules, far from being an obstacle to the exercise of Section 57, it's likely often to be a critical threshold issue that confers it in the first place. It's the very fact that you don't otherwise have power that it makes Section 57 available. Of course, the existence of a prohibition and the reasons for it are relevant for the court to take into account in the exercise of its discretion, but it's not in any way an obstacle. And we've seen cases to do with employee benefit trusts and indeed now pension schemes where express letters have been deliberately overruled by the court in its exercise of Section 57. And the other sort of overriding requirement for the court to exercise its jurisdiction as part of the discretion as to whether or not to grant the powers is where expediency, whether it is expedient. And some of the older cases talk about that as being if the power is in the interests of all of the beneficiaries under the trust. Some of the more recent authorities talk about whether it's in the interests of the trust as a whole. And another of the boundary areas which we have yet fully to investigate in the case law, particularly in the commercial context, is whether there may be circumstances in which the objects of a trust are wider than its immediate present beneficiaries, so as to fulfill the commercial purpose, for example, of a pension scheme trust. To give an example, which we'll come back to when looking at other possibilities, you have circumstances where the main object of the pension scheme trust is to provide pension or other relevant benefits for the employees of an identified employer. But of course, you don't owe just duties as a fiduciary to the present beneficiaries alone, because new entrants are admitted, new joiners come in on a routine basis. Bulk transfers come in. You are allowed to look at the objects, the potential beneficiaries of the trust more widely. And there might be circumstances in which the interests of the trust as a whole may be actually slightly different from the interests of the present beneficiaries within it. And with that, I'll hand over to Philip to tell you a bit more about the recent decision.
Thank you. Yes, it's time we cut to the chase and talked about the new case. So, this is the Penning Group pension scheme. Now, if I worked in the water industry, I might not want to be associated with sewage farms as the first image that people thought of. I think that might be a sewage farm, maybe I'm wrong. Anyway, this is all about a water industry pension scheme. So, there are two key parts of the narrative, 1989 and 1999. In 1989 we had water privatisation, and in relation to the relevant members of the scheme and the story, they moved from the WASF, the Water Authority's Superannuation Fund, into a new scheme which is known as the mirror image scheme. In other words, it provided benefits which were mirroring those that they'd had when it was a state-sponsored scheme. And there are a number of protections baked into the rules, as you perhaps would expect if you've ever looked at post-privatisation pension schemes. Lots of things got negotiated which would be unusual in a story that had always been in the private sector. And in particular, these members have a special protection in relation to the number of trustees that are going to be taken from membership, and they are entrenched, as we'll see, in the amendment power as well. Moving on 10 years, in 1999, we've got a water industry transaction, and we have a merger of that mirror image scheme into a larger scheme, which is the current scheme, the PGPS. And the protections are maintained in relation to the section, the style of benefits, which is being continued and to house the benefits of transferring members and their future accrual. We've got a closure to future accrual in relation to these members in 2021, and that has been taken place, quite important in terms of the balance of power type of issues you might think about. That's taken place contractually because a veto was exercised by those mirror image scheme MNDs to the closure to future accrual. So the right, the entrenched right there to have a particular number of MNDs with powers of veto has not just been a theoretical part of the story, it's actually been exercised in anger in the recent history, although what was proposed to happen on that occasion happened anyway, but through a different route, through a Southwest Tradesman type expedient. So that's the history. The key thing, of course, is to look at what the rules say, and they're on the screen now. So, key thing to notice is that we've got a requirement that there be on the trustee board at least 3 trustees or directors of a corporate trustee who are appointed to represent the mirror image scheme members, and that is stated independently of the number of trustees there are overall. So it's an absolute requirement for there to be 3. And then that's an entrenched requirement because the amendment power has got a proviso which prevents the amendment power being exercised in such a way that it removes the protections in relation to the mirror image section. So you can see the sort of obstacle that this scheme is coming up against as it modernises. It's no longer very common to have huge trustee boards of 16 people because it's found unwieldy and it's increasingly not appropriate in the context of schemes that close to future accrual, because without active members you don't have people who want to do that kind of thing anymore. So there's a confrontation between what the rules thought was going to be the steady state of the scheme, if you like, and the evolution of the marketplace. And that's the context in which the application under Section 57 was made, effectively for a removal, notwithstanding the restriction of the amendment power, of the requirement that there be 3 trustees from the mirror image section, and its replacement with the requirement there should be only 1. That, it must be said, in the context of a proposal to reduce the size of the overall trustee board. We're not talking about something that's targeted, if you like, as a weakening of the influence of the mirror image scheme sourced trustees, so much as a proportionate reduction in the number of trustees overall, and therefore a proportionate reduction in the number of mirror image scheme trustees. So, the judgment of Master Pester in March is summarised here, and I think the key things to take away from this are, well, perhaps all of these are important, but yes, it is important that we ended up with an uncontested disposal hearing. So, although there were some little frisons of potential difference of emphasis that were floated by the representative beneficiary, they didn't get in the way of the representative beneficiary supporting the outcome and saying, yes, this is something that is not inappropriate for the court to award in terms of authorising the transaction and the additional power. The basic approach for that is the Nomura principles, which come from rectification context. The judge decided that the legal role for the representative beneficiary was primarily to satisfy himself or herself, and therefore the court, that the requirements for the remedy or the release sought were met, and that's the structure of the jurisdiction in terms of the role of the Rep Ben that they're being called upon to exercise. The key point here is exactly how expediency is justified. Why is it expedient, notwithstanding all these elaborate protections, to permit a reduction from 3 to 1 of the mandated mirroring scheme trustees? Well, there are a number of points that were made in the argument which the judge found influential. The first one was a proportionality issue. As an overall percentage of the population of members, the mirroring scheme beneficiaries and members were a reducing proportion. They had been, I mean, not actually in the scheme of things a massive difference, but they had been kind of 15% in 1999, and they're now down to 9%, so they're reducing. More importantly, they were much harder to find now than they had been previously, in the sense that the average age of that section is now 79, whereas obviously in 1999, 25 years ago, it would have been a lot lower than that, if not quite 25 years lower. Yes, the obvious willingness of people to volunteer for such a role is obviously going to decline with increasing age. An important motivating factor which the judge accepted was relevant consideration to the expediency was, if you like, the desire from best practice to increase the efficiencies in a non-financial sense of the Board of Trustees by reducing the size of the board and making it slicker, recognising that in the modern world of governance, quite different from how it was in 1999, the amount of time and professionalism that modern trustees are required to devote to their activities is much greater, and consequently a smaller board is likely to be necessary to both maintain enthusiasm and also just to manage the supply of information and manage the skill levels of the trustee board. All those are relevant, and Judge Marsden said he was satisfied that it was expedient for the reduction to be made. One thing he didn't focus on, but which I have to say I think we should bear in mind is a really quite important element of this decision, because I suspect, first of all, Rep Ben might have said something differently had it been different, and I suspect also that the judge would have latched onto it had there been a problem. So even if we didn't mention it, it must be important that the real balance of power here was not being disrupted. Okay? In other words, there was a proportionate reduction in the overall size of the trustee board, but critically, the vetoes were being retained. So although there was only going to be one mirroring scheme trustee, there was still going to be a veto. So this wasn't a situation where the official line, if you like, from the employer and the chairman of the trustees is, oh, if only we remove that provision, there's a whole load of things we could get through that we can't get through at the moment because of the awkward score that was on the table. It wasn't that kind of process, and if it was, probably it would be rather harder to satisfy the judge on expediency. And I don't know yet whether you agree with that, but that does seem to be a sort of important silent point in the reasoning, probably. So I will move on to the procedure in just a second. Just one thing to say, though, we said at the bottom that we think it's the first application of Section 57 since the Cooperative Society case that Nick mentioned from the 1980s. Actually, realise that isn't quite true. There's one case from the noughties which was to do with the national bus privatisation. Remember, there was a lot of money that had to be refunded to the scheme after it had been paid to the government in the course of national bus privatisation, which then had to be distributed and winding up. And the main application there was for the court to approve the scheme of distribution amongst members with that surplus that was being proposed by the trustees. But an interesting little point, they got Section 57 to grant them the power to buy run-off insurance that they wouldn't otherwise have been able to buy with that money to protect themselves. So that's actually something that's worth bearing in mind as a practical example, something that would be useful. But yeah, but very rarely has it been used in a pensions context, and this was certainly the first since the noughties, if not the first since the 1980s. So procedurally, I think we can go through this reasonably quickly. It's something you would do by a Part 8 claim form, supported by witness statements. Obviously, the key focus of the witness statement is going to be explaining why it is that it would be expedient for the power to make the disposition or enter the transaction, or expand the management powers of the trustees should be made. That will be the focus of the evidence before the court. There will need to be a representative beneficiary. One thing that's worth saying is, it's not in the judgment, but I understand that the master did make some comments after the judgment about a boundary line with the private trust context. He said that it really was important in a pension scheme case that there should be a representative beneficiary as a check on the proceedings, because actually Section 57 applications in the private trust context are sometimes made without a defendant, without a hearing, and he did think that probably in a pension scheme it was important that didn't happen. So that may be an important unofficial procedural requirement which isn't represented in the judgment, but nonetheless is important. As here, you would hope that in an appropriate case, the representative beneficiary will not want to oppose the application. Similarly, as with rectification proceedings, communication to members is best practice. So that's something you'd perhaps expect, as set out in the Chancery Guide. And we think that in an appropriate case, it's the sort of thing that you could expect to, if you can get agreement with the representative beneficiary and all parties, then it's the sort of thing that can be done in a day before a master. And that may well be something that's a cheap way of dealing with a particular problem when you've conducted the cost-benefit analysis, which obviously is relevant to the whole expediency anyway. But sometimes it's worth thinking about this as a route to overcome a particular logjam or obstacle, rather than some other fancy footwork that you can come up with, which doesn't involve an e-court application. This might well be something that does have relatively low cost attached to it in an appropriate case, and which provides an easy solution to a problem that otherwise might be difficult. Nick.
And as ever, it's all very interesting hearing about someone else's past case, but the real question we're always interested in is, well, how will this help us going forward? And the future possibilities in the current era of surpluses in particular make Section 57 something that we should all be familiar with and have back on our radar. It's not uncommon to find, even now, that people haven't got express provision that the amendment power remains available in winding up. Sometimes there have been insolvencies sometime in the past where people were frankly busy worrying about other problems that had run up to the insolvency. An assessment period was triggered, went on for some years. At the end of the assessment period, of course, the legislation provides that the winding up is treated as having begun right at the very beginning when the insolvency ensued. And if you don't have an amendment power, and there are changes that it would be convenient to make to administrative provisions, whether to do with transfers or something else, you may have no power unless it's conferred by Section 57. Alternatively, you may have provisions which have been entrenched, whether they're post-privatisation type fetters, as in the Pennon Group case which we were talking about today. But an even more interesting area to my mind is whether or not Section 57 can be relevant to dealing with trapped surplus scenarios, which I know a lot of schemes are having to grapple with at the moment. Sometimes you've got prohibitions on return of surplus, even from an ongoing scheme, that were put in very old schemes when that was understood to be a requirement of the fiscal regime. And I've been asked recently about a particular scheme that's 200% funded on a buyout basis. It's ongoing, but there's no way they can actually use up all the money, and the employer would quite like to have some of it back. And is there a way of removing the prohibition on money being returned to the employer? Well, potentially, as part of a deal by which augmentations are given to members, you can see Section 57 providing a solution that trust law doesn't otherwise provide. Or what about, sounds almost heretical to suggest it, mergers in winding up? If you've got a scheme that is overfunded and a sister scheme which is underfunded, and you could merge the two in a way that would mean that all of the existing beneficiaries of the scheme in surplus would still get every penny, could you use Section 57 to do so? Now, of course, there's normally provision for augmentations, discretionary augmentations from surplus in winding up. But would that be, would it be an incidental effect rather than impacting or rewriting the trust to merge in the underfunded sister scheme so that everybody got every penny that they were ever intended to have? That you can see Section 57 being used creatively in the context of this era of surpluses. So that was, I think, all we had on Section 57. We can take questions now or deal with them in the coffee break. Fire away, Jim.
I'm going to ask the obvious question,
Yeah.
because the thing that's not in one of your square boxes is obviously benefit adjustments. And so Nick, you started off by saying, in effect, an existing FETA or prohibition is no bar.
Yeah.
Obviously ticking the other boxes around expediency and so on. So do you think there is would be any judicial appetite? We seem to be having a few more commercially minded judges with some interesting decisions recently for, in effect, a more pragmatic kind of, perhaps an approach where you've got an equalisation issue or a really complex benefit muddle, between past practice or conversions or what have you. Tricky, complicated, expensive. You might try and do a compromise, between company and trustees and try and get a court sanction to that. But is there a Section 57 angle? Because Philip, you stressed there's no balance of power implications, in the one you've got. So it's your case was kind of a no-brainer.
Yeah.
Where it gets interesting, obviously, is where it's not a no-brainer.
It's always best to knock off the examples that
I
are
agree.
easy
I
before
agree.
you go to
Yes.
that.
Yeah. No, I'm interested whether you think there could be any judicial appetite to start to use 57 in that way, or really it needs to be for obvious omissions where there's a gap and you've got alignment, as I say, administrative expediency, or maybe a bit of a deal. You have to see a deal around surplus, trapped surplus.
I think there are three strands to that. The first is you're not supposed to rewrite beneficial interests.
Yeah.
So if it was part of a scale benefit, I can see the court saying no, because you're then trying to rewrite someone's beneficial interests.
Yeah.
That was their accrued right. I can see that the next step would be for you to say, well, what about the boundaries between, for example, Section 67 and subsisting rights, and perhaps encourage FETA that wouldn't be caught. There, I think the issue is going to be that, quite apart from the fact you'd be rewriting beneficial interests, which you're not supposed to use Section 57 to do, the court is, in the exercise of its discretion, I think is going to be very disinclined to overwrite a statutory prohibition. So if you had, if you, for example, tried to abrogate Section 67, I think the court would just say no.
Agreed.
Yeah.
Agreed. So fairly rules based.
But I think the more interesting bit, the more controversial bit I can see, is what in the pensions context you're going to say is the beneficial interest. Are you going to take the hardline approach taken by some cases, which say it was a defined benefit, the bit that was really defined was the pensions formula, the scale benefit, anything else is incidental? Or are you going to take the looser, more benevolent formulation that was used in some other cases of saying, oh, but members have a genuine interest in surplus on winding up and the possibility of discretionary increases, and we shouldn't allow that to be interfered with by the conferral of powers under Section 57. And that, I think, is a live battleground where we might see litigation over the coming year.
So, all along the same lines, if you think about the Halkirk case, Move Act from a few years ago. So that was all about whether you could have in winding up a transfer, bulk transfer, which didn't secure all the scale benefits, but which was going to secure in a new scheme benefits which were comfortably better than the members would get in the winding up or from the PPF. Yeah. So that was the decision of Sarah Asprin was that you couldn't have a GN68 certificate in those circumstances. You couldn't have a bulk transfer without consent. And of course, in practical terms, where that's left us in a whole lot of cases like British Steel, is that trustees avoided their members going into the PPF if they wanted to, getting elected transfers to new schemes, and they were at the mercy of sharks who came along and missold them alternative transfers. In other words, there'd be many trustees who think it would have been such a good thing if we'd been able to do the bulk transfer without consent in that situation by transferring into a scheme which would provide lesser benefits, but benefits that are better than the PPF benefits. Now, you can potentially see, I don't know if you agree with me, but you can potentially see permitting a transfer which would not be, is not something within your powers because of Regulation 12, but which is expedient and beneficiary.
Statutory prohibition though, isn't it?
Well, is it? I don't know. It's on the borderline. It's not the same though as Section 67 because it is about trying to secure the benefits on a transfer, and it's certainly not saying that you have a right to receive the same benefits. But yeah, I mean, these are possibilities that we can discuss. I think many of them will, at the end of the day, end up being things that judges would be nervous about. But it doesn't mean that it's not beneficial to try and push the envelope a bit and see how far we can
In
get.
an exceptional case.
David, knowing that your question will be difficult and therefore I don't want to answer it, and looking at the time, we are running, because like the trains, a little bit behind time. May I suggest that we deal with further questions over coffee break? Please nobble any of those involved, including Nick Hill, who's lurking at the back and acted for the representative beneficiary. I think Victoria Brown, who was also involved, may not be able to have been here today. By all means, ask us further questions over the break.